And now this is, I know all of you say, very little about what is an intellectual property rights. So that's why I start with the very basic, what actually is IPR. Okay. So it is intellectual property rights are the rights given to persons over creation of their minds. All of you may be knowing what actually is property. Okay, something useful that you possess. You may generally define it as a property. Now, what we are talking here about intellectual property. Okay, so that's a creation of your mind. And they usually give the creator an exclusive right over the use of his or her creation for a certain period of time. So, the creator of the intellectual property, so he has a sole right. Okay, and that is for a given period of time. And that is about intellectual property. Right. So, property in general we can classify as tangible and intangible properties. Tangible means which are actually physically present. You can see, you can feel it. Right. So, such properties we call it as tangible properties, which you cannot see, which you cannot feel. So that we define it as intangible. Intangible again further can be classified as movable or immovable. Okay. So movable can be your say car, you are having a car, which can be a tangible movable property. And immovable, it could be a building, okay, which cannot move from a place. And now when it comes to the intangible, it is the intellectual property. It's the only one property in that category. And further you have this as industrial property related and copyright related. And under industrial property related, you have patents, designs, trademarks, and GIs, that is geographical indicators, GIs. Okay, types of IPRs, intellectual property rights. Okay, we have 5 basically: patents, trademarks, industrial designs, geographical indicators, and copyrights. Okay. Now, during that formal function, Professor Hector told the purpose of having this kind of the workshop for the first year students, because you all must have the awareness about the patents basically, because this is what is most related to us as engineers for technology. So if you have this awareness right from your first year, then it is possible for you to think of patents when you actually think of new ideas or innovations. And second thing is also, okay, of course, all these are important for us. We'll briefly just look at it, each of these. Now, features of an IPR, okay, I mentioned in the beginning, exclusive rights given to person for the creation of their minds for certain period of time. Okay, he or she has an exclusive right. That's a legal right, because if someone infringes on his right, he has a right to sue him. Okay, under the law. Intangible potential asset. Okay, monopoly. That person has a monopoly over his creation. Okay, and negative rights. That means it prevents others to use his or his creation for a different time. Okay, other person has a negative right, so he cannot just copy your creation and use it for some purpose. And why? Okay, why I need to apply for patents, or why I need to apply for trademarks, why I need to apply for copyrights. So to provide an incentive to individuals for new creations. Okay. Now, later I'll speak about it. When I need to apply for a patent, okay, when there's an innovation, now you may think whether I should apply for a patent or whether it should be quiet. Okay, so the first thing is it provides incentive. That means if you think that you can make more money, if you can make money out of your innovation, out of your idea, then you need to definitely apply for the patents. To accord due recognition to the creators and inventors, and to ensure material reward, as I told you, mentioned, okay, the money Okay, that is an important factor of all these things, right? If it fetches money to you, definitely you need to apply for patent. And to make available genuine and original products. Okay, so first one under this IPR, okay, there are 5 things, right? So we'll briefly discuss about each of one of them. The first one is a patent, and which is again is very important for engineers. Okay, now this patent is granted by Government of India in India. Okay, it is territorial. It is because when you apply for patent in India, it will be granted in India. Okay, and if you want to apply, if you want this patent to be issued or you want to use it in other country, you need to apply for patent in that particular country. Okay. So and this is given, patents are given for inventions. Okay. It is given for inventions, basically for the products, processes, materials, and competitions. So if you innovate something here, then you can definitely apply for the patents. And it offers technical solution to a technical problem. Okay, that means when I say invention, right, what exactly you are talking about here is nothing but the invention that offers technical solution to a technical problem. So if you have something new, if you have a new solution to a problem, okay, so that can be patented. And it could be a new way of doing something also. That is nothing but the process, right? Could be a new way of doing something. And important thing is the technical information about the invention must be disclosed to public benefit communication. Okay. So when you are applying for a patent, it is not that it's a secret for you. Okay, it's not a secret for you, but you need to make it public. Okay, so there is a process where you have to disclose all the details about your invention. Okay, to the government of India through the application. Okay, and what kinds of protection you get once you apply for patent, and if you say you are granted patent, generally it takes about 1 to 1.5 years after you apply for the patent, okay, to be granted. Okay, it's not that the moment you apply for a patent it will be granted. It will take at least 1 to 1.5 years before it is granted. If everything is fine, so it will be granted patent only after a year or 1.5 years. Okay, it will be not immediate. Until then, it will be there in the public domain. Anybody else, if he thinks that okay, this is not his invention, it's my invention, they can counter it through the portal. So once it is granted, that is after the completion of this 1.5 years, okay, if there is no complaints received regarding this application, and then you will be granted the patent. And generally the patent will be granted for 20 years, even in India also it will be for 20 years. So what kinds of protection you get once you are granted with the patent? The first one is the patent owner has exclusive right to prevent or stop others from commercially exploiting the patented invention. Okay, so that's basically it is done for that purpose. Patenting is done for that purpose. Okay, if you think there is something from which you can make money, so you should apply for it. Patent. Okay, and if someone else copies your invention and he takes advantage of it commercially, then you can always take him to the courts. And patent protection means that invention cannot be commercially made or used or disputed or imported or sold by others without the patent owner's consent. Okay, if somebody wants to create it or someone wants to use it, they should get the owner's consent. Okay. And this is about the Patents Act in India. Okay, initially it is done in the year of 1970, and then there were amendments. Okay, that was done in the year 2005. Okay, so I will talk more about this Patent Act in India. How long? Okay, a patent is granted. Generally, it is for 20 years. Most of the countries, okay, patent is granted for 20 years. That means once it is granted, the person has exclusive right for 20 years. Okay, he can sell it or he can make money out of it for 20 years. And after that, it becomes public. Anyone can make use of that technology. Okay, territorial validity, this is what I told you that time. So, if at all you want to do a business with your new invention only in India, then you have to apply for patent only in India. Okay, but if you think that you can even sell the product and make money in other countries like US or UK or whichever country, then you need to apply for patent in that country also. It is not that you are granted patent in India but not applied in US, so it won't be valid. Someone else can copy and do money out of it there in that country. So if you think that your product is valid there also, then you should apply in all those countries where you think you can make money. Okay? And what's the criteria? Now, when you think that you have a new idea, you have some innovation, some technology that you think that it is new, okay, then how do you decide whether it is actually new or it's a copy, whether it already exists, somebody has already made it, somebody has already got the patent for it, okay? So, the first one is what? Novelty. Okay, the idea should be novel, the new. That is the first criteria. Next, inventive step, or it must be non-obvious. Okay, you cannot claim a patent for something very obvious. Every day you see. Okay, every day you see that people are using it, and that we cannot claim that it is my invention. Okay, and it should be capable of industrial application. Right. If you think that you have made some innovation, some new idea, if it's of no use for anybody, then there is no point in applying for a patent. If you think that yes, I'll apply for a patent, it will not be granted. So, when you apply for a patent, you should think that, you should first see that whether it is of any industrial application. Okay, otherwise it won't be granted. And then the last one is, it will not fall within the provision of section 3 and 4 of the Patents Act 1970. There are 3 sections which exclude certain things. You cannot claim, right? So what are those? Section 3 and 4. Okay, section 3 lists which are not inventions. Okay, frivolous or obvious. Okay, as I mentioned, everyone sees. Okay, and I am applying that as my invention. Contrary to well-established natural laws, okay, you'll be studying different natural laws. Maybe in your first year, even in second year, study related to so many laws you study. Now you are claiming something which is against this law. Okay, your invention claims that okay, which goes against the well-established natural laws. Okay, so that won't be granted patent. Injurious to public health. Okay, you are inventing something which can easily kill people. That won't be granted patent. Okay, which is injurious to public health. Then mere arrangement and rearrangement. Okay, there is a product which is already existing. Okay, I am just rearranging the things or reassembling and giving it as a new product. Okay, so that also won't be accepted. Discovery of scientific principle, okay, that becomes invention. Okay, so that won't be granted patent. And then discovery of living things or non-living substances in nature. Okay, you found a new variety of a frog in your area, and you say that okay, this is my invention or creation. You cannot claim like that. Okay, and method of agriculture or horticulture, okay, because that is protected in some other, I'll come to that. Okay, so even the the methods related to the agriculture, if you found a new method, again cannot be claimed in a patent. And a mathematical or business method or a computer program. So many of maybe of computer department here. Tomorrow you write a new program, totally new program. Okay, that runs nice and does some good thing, right? Again, that cannot be protected under the patent. And section 4 is atomic energy related. If you do any invention related to atomic energy, it will never be granted patent. Okay, so these are two exclusions, okay, which prevent you from getting patent. Examples are many. I have listed some here. Okay, maybe the Mangalore iPhone and and in front of it I have written what actually is the patent name. Okay, what actually is the patent name? Because if you search iPhone, you will not get the patent list there. Okay, it is registered as electronic device. Likewise for all these. Okay, and most of these are registered well below, before 2000. Okay, 90s. This Bluetooth technology, I think it is 1994 somewhere in that year it is registered. So it has crossed that 20 years period. Okay, and similarly, I may give some other examples like you must have seen this can opener. Okay, right. I don't know whether you have seen a beer can, right? So it comes with a special opener, right? And it is patented. It is a patented innovation, and that owner gets so much money for every bottle that is created. Okay. Similarly, you must have seen the cricket. If you are watching cricket, right? The cricket base that goes off when the ball hits the wicket, and you see these days there will be some light LED glowing, right? Electronics and something, okay, right? And that was created by someone in Australia, I think. And he gets some crores of rupees for every match. For every match, that guy gets some crores of rupees. Just think how many crores of rupees he gets because of these matches, right? Because this ICC has obtained his consent to use that, and for that they are paying money. Okay, so likewise, everyday life you see so many things which are patented. That means because you use it, the creator gets money for it. Okay? Yeah. Now, why we are stressing for IPRs here in India? Okay, and also why we started right from your first year. Okay, because you see, okay, who has the maximum patents today? Okay, the China has the maximum patents today. Okay, nearly 5 lakh odd. Okay, whereas we are here, I think this has increased. This is little old data. Maybe right now something around 50,000 we have. Okay, but that is still far behind these two countries you see. Okay. Okay, so it is not because we don't invent or we don't innovate. Definitely it's not because we don't innovate. It is because we don't apply for patents. We don't know it. And in some other country, okay, they may be using your innovation. Whatever you have invented, they may be using and they may be making money. Okay, so it is because we don't have awareness about IPRs, we don't have awareness about patents. okay, we are lagging behind in the application of patents. Even though we have a lot of innovations, okay, lot of new ideas over the years, right? So, but still we don't have patent because we are lagging behind in applying for patents. The second IPR, okay, second intellectual property is industrial design. First one we spoken about the patent. The second one is industrial design. Okay, so something I've displayed here. Okay, earphone, right? So here it could be ornamental or aesthetic aspect of a useful article of industry. Okay, every day you may see a new phone, a new design of a phone. Okay, or you may see different designs for all your earphones. Okay, likewise, you may see different watches. Okay, or it could be the smart watches, the different designs. All those are, you cannot claim it for patents because it's only the design that you're changing. Okay, so those are protected under industrial designs. Okay, if at all you do something, some new shape, maybe for a mobile phone, a new, then all such kind of things must be protected under what? Under the industrial designs. And aspect with which differentiates from products is the shape, aesthetics of a product. So then it has to be protected under industrial design. Okay, and now distinguishing feature, again I will come to this trademarks later. The ornamental or aesthetic aspect of an article consists of three-dimensional features such as shape, surface or texture of an article, or two-dimensional features such as patterns, lines and colors. Okay, and design makes the product attractive and appealing to the consumers and adds to its commercial value for that reason. Okay, because many of you say purchase a phone by just for its look. Okay, just for its look or appeal, you may purchase a new phone. Okay, you are not too much worried about its configuration and other things. Okay, it looks very nice. I may purchase that. Okay, so such designs must be protected under industrial designs. Okay, so some other things I've listed here. Maybe the shape of a bottle. Okay, then your shoes or chappals, right? And new shape design for an automobile, and maybe for the furniture, jewelry, shoes, okay, all these things. So exclusive right against unauthorized copy. Okay, if you have done a new jewelry which is very attractive, people are coming to purchase it, right? Someone else cannot copy and sell that as the product because you are protecting yourself by applying for industrial design. So protection normally lasts for an initial 10 years, after which it can usually be renewed for, in most cases, up to 50 years. So total will be granted for 25 years, first for 10 years and then for 15 years. Next is trademark. Okay, trademark. So here I have listed our college logo, right? So this is also a trademark. Okay, our college logo is also a trademark. So generally brand or logo, okay, and that must be protected under trademarks. You cannot patent it, you cannot go for industrial design. And a visual symbol which may be word, signature, name, device, all these things. Okay, and any name which is not unusual for trade to adopt as a mark. Okay, and device or symbol or monogram. Okay, it could be something like this. Shape of goods or their packing. You can also get the trademark for your packing also. Okay, and combination of colors or even a single color in combination with the. See, all these are trademarks. Okay, so you cannot copy these things because they are protected by this trademark. Okay, even you are just changing the name, instead of you have to keep something else, but you exactly copy the shape like this. You cannot do that or any other thing. So here I use the same thing, but I'll change the BMW to something else. You cannot do that. Okay? So all these are some of the examples for trademarks. Some more are here. Then comes the copyright. Okay. Copyright is actually a legal term describing rights given to creator for their literary and artistic works. If you write a story, a new story, then you can apply for copyrights. Okay. You write a new book, you can apply for copyrights. Okay. Could be anything, literally, which is not copy. Your own writing. So that must be copyright. Okay? And copyright comes into existence as soon as work is created. In fact, it comes into existence as soon as it's created. The moment you write a new book, it is copyrighted. Okay? But if you want actual legal protection, then you have to register. That's different. Okay? But otherwise, you can always sue that person. Okay? If you think that someone copied what actually you originally have written. Okay? So that is what this. As soon as the work is created, it comes into existence and protects skill and labor employed by the creator in production of his work. Okay? The works covered by copyright include, okay, literary work, okay, novels, poems, all these things. Even computer programs. Remember, computer program, we cannot apply for patents, but if you think that you have written a program which is useful and which you think it's your own, if you want somebody not to copy your program, then you can copyright it. Okay, you can apply for the copyright. And films, musical competitions, dance, okay, theatrical productions, right? Okay, every day you see new music, okay. The videos coming, all those things are protected under copyright. Then artistic works also, such as paintings, drawings, okay, photographs and sculptures, architecture, advertisements, maps, technical drawings, all these things, okay. So because you cannot claim protection for these things in any other category of IPRs. Now for the copyrights, how long you get? You know, for patents it is 20 years from the date of granting the patent. It will be valid for 20 years. Whereas copyright, okay, suppose say you write novel today, okay, it comes into existence there, and then till when it is valid, till when you can get the novelty, royalty for it, okay, that is, in India it is up to 60 years from the date of your death, okay, from the date of your death up to 60 years it is valid, and in most other countries it is 50 years. Okay, in US it is 70 years. In most other countries it is for 50 years from the date of the death of the author. Okay. And the last one, the last one in this is a geographical indicator. Okay, the name itself says, okay, geographical indicator. Or GIs, generally called as GIs. Okay, they identify agricultural, natural, or manufactured goods associated with a territory, region, or locality. Okay, so we have so many things in our region also, right? I'll come to that. Okay, and what happens here is it gives protection to the group of people or association. It's not for individual. Okay, when it comes to GI, it is not for an individual, for that people over there in that region. Okay. Involved in the production of the product using traditional skills and knowledge. Okay. Could be something like Chennapatna Bombay. Okay. Or this Udupi Mattu. Okay. Some of you may be aware of this. Right. So that is in our locations here in Karnataka. Those are the geographical indicators. You may have some other things also, right? The manufactured goods should be produced or processed or prepared in that area. Okay. So this gives a special quality to the product due to the geographical, climatic environment, reputation, special manufacturing or farming skill, traditions, other characteristics attributable to the origin. And it consists of the name of the place of origin and originates from a definite geographical area. Okay, so some of the examples I've listed here, maybe Darjeeling, then Kanchipuram sari, okay, Kalapuri chapels, Tirupati laddu, okay, and Nag orange, and which I have told in the beginning, right? Some examples of GIs, okay, they're listed here, okay. Yeah, now what is the relation among all, right? If I innovate something, or if my company tomorrow innovates something and gets a new product, okay, now which one I should go for? Whether I should go for patent or trademark or copyright or GI. Okay, so here is one relation I have shown. Okay, you may see a Coca-Cola bottle like this, right? And you see the logo of Coca-Cola is example of trademark. You may see here this logo. The shape of the bottle is a industrial design. Okay, they have protected that bottle shape with the industrial design. Then patent have been obtained with respect to bottling equipment. To make that bottle, they may have a special device. Okay, special equipment, and that they must have obtained patent. Understand? So that others cannot copy this machine and do the similar kind of bottles. And copyright in respect of the text, you may see here so many things written here. Okay, under it. Again, if someone should copy that, they have to get the copyright for it. Okay, so what is the meaning of it is, a single product can be protected by more than one IPR. Okay, so a single product can be patented, trademarked, or copyrighted, or even you go for industrial, the designs. Okay, even here also you see, okay, this iPhone, iPhone itself is patented. The iPhone, it's a technology, so that itself is patented, and there could be trademark of this, okay, and here also, okay, the same thing I have listed here, and this is industrial design, and here is a geographical indicator. And now the next topic that is related to this IPR, okay, IP management for startup. Suppose say you go for, you have some innovation and you think of doing some new business with a new innovation, right? Then you go for a startup. Okay, now what is that which is very important when you do that? Okay, so IP management is very, very important for a startup. Okay, so any startup needs to be cautious in selecting its trade name, brand, logo, packaging for products, domain names, and any other mark which it proposes to use. It's because of two reasons. Okay, because of two reasons. First one, you cannot by mistake also copy someone else's name, someone else's logo, right? If you do that, you're getting into trouble tomorrow. Understand? That person may sue you tomorrow and drag you to the court, and you simply wasting your time into all those legal processes. That's the first thing. Second thing, if what you have done is something really new and someone else shouldn't copy. Okay, someone else shouldn't copy, and and before you apply for say IPR, okay, he is doing it and is getting protected by it. Okay, so that is why applying for this or knowing about IP and IPR is very important for a startup, and must do a proper due diligence before adopting a trademark. Okay, so for the same set purpose. The trademarks can be broadly classified into two following categories. So this is very important because when you start a company or a startup, the first thing is a trademark. Maybe the name, the logo, the brand. Okay, all those are the first things. Your innovation later, right? Understand? All those are first things. Now, how do you choose a name? How do you make it as a brand? How do you make a logo? How do you make a logo? All these are important for a startup. Okay, so that's why they are broadly classified into these 5 categories. Okay, the generic could be a salt. You're actually producing or packaging the salt and you give the name as salt itself. Okay, or your name starts with salt something else, or ends with salt. These are generic names. Okay, or descriptive. You may use fair for a fairness cream. Okay, you are producing a new fairness cream and your name starts with fair. Yeah. So something like that. Okay. Again, it is descriptive. The name itself describes what is your product. Okay. And third one is suggestive. Habitat. Okay. Habitat of that location. Okay. So that is the third one. And then fourth one is arbitrary. Apple. Apple is producing iPhones, not Apple. They are not selling apples. Okay, it's an arbitrary name. Okay, and fourth one is invented or coined. You are coining a new name. Okay, like Adidas. You are coining a new name. Okay. Now, so it could be of any of these. Now, which is better? When you go for a new company, when you give a new logo, a new name, which is better? So the strongest mark is invented or arbitrary. The last two. These two are the strongest trademarks. Okay, you must always look for such trademarks. Okay, you may do a new software company called as Orange, Mango. Okay, so likewise, it's arbitrary. Even though it is nowhere related to that jackfruit, you are naming it as jack. Okay, and the weakest is obviously the first two, generic and descriptive. Okay, generic and descriptive, they are the weakest trademarks because it's possible that many others would have given the same name, same brand, okay, and easily they can sue you, they can drag you to the legal process. Okay, that's why you must avoid those two things. And this is about how India follows this classification of trademarks because all those things must be registered. Okay, so for every startup seeking to trademark a good or service has to choose from the appropriate classes. There are 35 classes of services there. Okay, and ensure that mark is not being used by any other person in India or abroad. Okay, that you need to do in the beginning. And it is important to note that India recognizes the concept of well-known trademark. Well-known trademark like Google, Apple, right? All these are well-known trademarks. India recognizes. Someone tries, someone tries to copy those things, will not be granted. And principle of transport reputation. Suppose say Google, Apple, they must have registered those trademarks in India also. But if there are some companies which they have not registered, but very well-known companies, I think forgot a company like IBM or something. Volvo they have not registered it trademark in India, but still India recognizes it. Okay, So someone cannot copy that Volvo logo in India and make the company. Okay. So trademarks can be protected under statute law under GM Act and common law. So if a person is using similar mark or similar related goods, right, other person can file suit against that person for violation of IP rights, irrespective of the fact that the trademark is registered or not. Okay. Remember, registering registering the trademark and the design, industrial design. These are compulsory. If you don't do it, tomorrow someone else copies, you don't get any protection. You cannot do anything. Okay. Whereas registering for copyright and GIs is optional. Okay, you don't have to register, but if you register, it is always good. Okay, if you register, it is always good. So that is what the last point says. Okay. So while using any technology or invention, the startup should check and confirm that it does not violate any patent right of the patent. Okay. So this is for any startups. That is very important. If the startup desires to use any patent invention or technology, the startup is required to obtain a license of the patentee. Okay. This is about the infringement. What if you copy someone else's IPR? Yeah. So what strategies startup should adopt? Okay, just listed are make intellectual property protection a priority. Okay, the moment you start or go for a startup, first priority is to do this. Okay. Register intellectual property rights. Even if it is a copyright, you register it. Okay. And due diligence of IP rights, as I told you, okay, because of two reasons. Okay, if you are copying the name or logo of someone else, you may drag it to the court. That's one thing, and someone else should copy your logos. Okay. Implement clear and effective policy and strategies for protection of IP right agreements related to the intellectual property. I think I have come to the end of this.